Happy New Year, all. Thank you for joining us this evening. I'm Gavin Cleesby, the Director of Programs, Exhibitions, and Community Partnerships for the Massachusetts Historical Society. It's nice to say that we have a very large group of people joining us online and a more intimate group joining us in person. So thanks to all of you who made it in person, and thanks to everyone joining us online. Apparently it's time to start. We need to adjust the clocks here. This evening, we'll welcome back Brad Snyder. Professor Snyder is a former MHS fellow and a researcher who spoke at MHS back in the spring of 2017 on his earlier book, The House of Truth. He teaches constitutional law, constitutional history, and sports law at Georgetown Law School. Beyond teaching and writing about law, he has also written 2 critically acclaimed books about baseball. He is a graduate of Duke University and Yale Law School. This evening, he will discuss his most recent book, Democratic Justice, Felix Frankfurter, the Supreme Court, and the Making of the Liberal Establishment, which expands on the history he wrote in The House of Truth. In this new work, he delves into the career of Supreme Court Justice Felix Frankfurter. Professor Snyder argues that characterizations of Justice Frankfurter as a judicial failure misunderstand his position and his legacy as a pro-civil rights liberal who advocated for judicial restraint. So, for anyone who may be joining the Massachusetts Historical Society for the first time, whether in person or online, we have been collecting, preserving, and disseminating history for the last 232 years. We are the first historical society in America, dating back to when you could write to Paul Revere and he might write back. We maintain a research library and an amazing collection of material with close to 14 million manuscript pages. We make this collection available to the public and to researchers for free, and also host a wide variety of programs. Just as a sample, we have both 2 public programs this week and 2 seminars, all of which are available to the public. We're only able to host programs like these thanks to the support of our members and donors, and we hope you'll return for future events and you'll consider supporting MHS. So without further ado, please join me in welcoming Professor.
Thanks, Gavin, for having me, and Olivia for organizing this event today. I'm really indebted to a lot of people at the Massachusetts Historical Society. I've been researching here for a very long time. I just want to name a couple of people who've been really helpful. Anna Clutterbuck Cook, some who are here and some who are not. Brenda Lawson, Kate Veens, Peter Drummy, Conrad Wright. They all helped me along the way. So it sort of takes a village to get a book of this size done, and the collections here are incredible. And I'm going to completely depart tonight from my normal chronological talk about the life of Felix Frankfurter, and it's an amazing life, right? He arrived here at 11 from Austria, not speaking a word of English and never having heard one spoken. By age 23, there he is at 19, third in his class at CCNY. By age 23, he's first in his class at Harvard Law School. Within a few years, he's on a first-name basis with Theodore Roosevelt. That's a meteoric rise for any person. And it's an amazing story. But I want to talk about how some of the collections here at the Massachusetts Historical Society really helped me think and write about this book, and then talk about his life through those collections. I happen to have the son, Charles M. Wazanski, of Judge Charlie Wazanski here, and Judge Wazanski's papers are here at MHS as well as at Harvard Law School, but the MHS collection was incredibly helpful to me, and I want to explain how. And then there's another collection I want to talk about. Judge Wazanski grew up here in Boston. He was the son of prominent Boston Jews. He went to Brookline High School, and then he went to Phillips Exeter, and then he went to Harvard College, and in 1930, he graduated from Harvard Law School near the top of his class. And that's where he encountered Professor Felix Frankfurter, who, beginning in 1914, was a professor at Harvard Law School. And by 1930, Felix Frankfurter was really at the height of his powers and really at the height of his notoriety in Boston. And that's because 3 years earlier, in 1927, Frankfurter published an Atlantic Monthly article and a book about the robbery and murder convictions of Italian anarchists Sacco and Vanzetti. There's Sacco and Vanzetti right there. Sacco is on the right, and Vanzetti's on the left. And the collection here at MHS that really helped me with the tell this story of publishing this article and publishing this book was Ellery Sedgwick's collection, and he, of course, was the editor and publisher of the Atlantic Monthly. And the problem with the publication of Frankfurter's article and book was he published it in March of 1927, when the case was still pending before the Supreme Judicial Court of Massachusetts, and a lot of people were really outraged that Frankfurter would publish this article in this book, which really, in Frankfurter's eyes, showed that Sacco and Vanzetti's trial had not been fair, that the trial judge in the case, Webster Thayer, had been prejudiced against them, and that they had not gotten a fair shake at trial, and they were really on trial for their anarchist beliefs and not for what they had allegedly done to the paymaster of a shoe company who was shot and killed, and the money was taken. And really, Frankfurter, because of the timing of the publication of this book and this article, became the accused instead of Sacco and Vanzetti in Boston. And Ellery Sedgwick's papers really helped me show that, because all of these letters poured in to Sedgwick about the case, including from a U.S. Supreme Court Justice and notorious anti-Semite James C. McReynolds. And here's what McReynolds wrote Ellery Sedgwick. He complained to Sedgwick about unsympathetic assaults upon the courts by men with crooked minds, referring to Frankfurter, defended the Massachusetts court and insisted his faith in them, this is a quote, faith in them cannot be shaken by ill-natured flings from an exotic mind. Again, referring to Frankfurter. Even Sedgwick himself, who had to distance himself from Frankfurter in Boston in 1927, Sedgwick, when he was meeting with Frankfurter during all of this hubbub, didn't meet with him in public places like, or some of the prominent private clubs that Sedgwick belonged to, like the Somerset Club. He met with Frankfurter in this out-of-the-way, poorly lit hotel on the edge of town, so people in Boston would not see them together. And this was Frankfurter, the kind of radical. He was perceived to be a radical after the Sacco and Vanzetti case. He locked horns with the dean of Harvard Law School, Roscoe Pound, and was never friends with Pound again after the case. He clashed with the anti-Semitic president of Harvard College, A. Lawrence Lowell, over the Sacco and Vanzetti case. This was the Frankfurter that Charlie Wazansky met. In that 13-year period from 1914 to 1927, Frankfurter was really building a network of Harvard law students, and he was really inculcating them with certain beliefs. And that belief was, don't go to a New York law firm, don't go to a Boston law firm, don't go to a Washington law firm. That the highest calling for a Harvard law student is public service, and that they should be aspiring to go work in the federal government. And you know, Wazansky's kind of Exhibit A, right? So Frankfurter made it his mission to get to know the editors of the Harvard Law Review, who in those days only get on the Law Review because of their grades alone. And he took an interest in their personal lives and their aspirations in their careers. And then he would tap the sort of best and brightest of those editors to clerk for federal judges. So he was choosing federal judges for two Second Circuit judges that Wazansky clerked for, Augustus Hand and his cousin, Learned Hand, and he was also choosing law clerks from those Harvard Law Review editors for Oliver Wendell Holmes Jr. And Louis Brandeis. And so Wazansky is, in some ways, has an interesting relationship with Frankfurter. I would describe him as kind of like the prodigal son. He was a little bit stubborn and obstinate, and really wouldn't do the things that Frankfurter wanted him to do. And let me just give you an example. After Wazansky clerked for Gus Hand and Learned Hand, there's a famous aphorism, by the way, of Robert Jackson that he said, you quote Learned, but you follow Gus. Meaning that Gus was the better judge, but Learned was the better stylist. But be that as it may, after Wazansky finished clerking for Learned Hand, he was working at Ropes and Gray, and Frankfurter really wanted him to clerk for Brandeis. And Wazansky said no. He refused to do it. Now, for whatever reason, I don't know what the reason is, but he wasn't going to be molded in the exact way that Frankfurter wanted to mold him. But Frankfurter didn't give up on Wazansky. Once Franklin Roosevelt became president in 1933, Frankfurter was FDR's principal outside advisor. In this day and age, I hesitate to call him this. He was kind of the Steve Bannon, if you will, of the Roosevelt administration. This outside figure, right? You know, for the Wilson administration, it would be Colonel House. Was to Woodrow Wilson, but this was Frankfurter to Roosevelt, and Frankfurter was taking all of these students who he was pushing to go into public service, starting with judicial clerkships, into the Roosevelt administration, including Charlie Wazansky, right? So in 1933, he persuades his friend Francis Perkins, the Secretary of Labor, to make Wazansky her solicitor. And he had to be confirmed for this position as solicitor, and the confirmation fight was rough, and Frankfurter was fighting behind the scenes for Wazansky's confirmation, and an anti-New Deal newspaper blamed Frankfurter for Wazansky's position as Perkins' solicitor, and this was what the New York Daily News said. It said 3 words: politicians take note. Right? They saw Frankfurter as this kind of Svengali figure in the New Deal, populating the New Deal with a lot of his former students, a lot of them Jewish, right? The papers often called the New Deal the Jew deal because there were so many Jewish Frankfurter students in the administration, including Wazansky. Wazansky played an instrumental role with Frances Perkins. She described him as like a walking stick, and a really firm, helpful walking stick. But in a couple of years later, Frankfurter needed him somewhere else in the administration. The Supreme Court of the United States was striking down all of FDR's New Deal programs, left and right. FDR passed new laws, new Deal programs that historians refer to sometimes as the second New Deal, and they needed good lawyers in the Solicitor General's office to defend them. And Frankfurter, after a lot of lobbying, persuaded Wazansky to go into the SG's office to work for the Solicitor General, Stanley Reed. And I have to say, Wazansky stood out among all of Frankfurter's former students in the Solicitor General's office as the best advocate of all of them before the Supreme Court of the United States. In fact, in 1937, Wazansky and Robert Jackson defended the Social Security Act before the Supreme Court successfully. That resulted in the Supreme Court's decision in Stewart Machine Company versus Davis. Wazansky goes back into private practice with Ropes and Gray after that, but Frankfurter has not forgotten about Wazansky or about public service. And in 1941, Frankfurter and Learned Hand lobby FDR directly. Frankfurter's now a sitting Supreme Court justice doing this, but I'll get to that in a minute. He's lobbying FDR to put Wazansky on the bench. And in December of 1941, FDR nominates Wazansky to go on the bench. And from 1942 to 1986, Charles Wazansky Jr. is one of the best federal judges in the nation by far. Well, let's go back to Frankfurter for a minute. In 1939, Roosevelt nominates Frankfurter to the Supreme Court. Frankfurter becomes the first Supreme Court nominee to have a kind of no-holds-bar nomination hearing. And after Frankfurter, every nominee testifies before the Supreme Court of the United States. To Frankfurter's left is Dean Acheson, who's his former student and lawyer at the hearing, although he did absolutely nothing. He was pretty much a potted plant at that hearing, to quote Brendan Sullivan, because Frankfurter did all of the talking. But what Frankfurter's nomination really brought out was a lot of anti-Semitism. In fact, Arthur Hayes Sulzberger and Henry Morgenthau Sr. counseled FDR not to nominate Frankfurter to the Supreme Court in 1939 with the rise of Hitler and the rise of anti-Semitism, both in Europe and in this country, because they were afraid of the backlash from Frankfurter's nomination, and indeed it did produce from backlash. There were a lot of wingnuts who testified at Frankfurter's nomination hearing. This is Elizabeth Dilling. She was a professional communist hunter, and she got herself in a little trouble in the hearing when she accused several members of the Senate Judiciary Committee, as well as Franklin and Eleanor Roosevelt, of being communists. That was sort of the end of her testimony that day. But most of the people were like Elizabeth Dilling. They were pretty much off their rockers. Here's the reaction. Here's the reaction in Nazi Germany to Frankfurter's nomination. This is a political cartoon from Berliner Zeitung, which portrayed Roosevelt as basically a prisoner of the Jews, right? That's, a stereotypical Jew on Roosevelt's back. I can't translate the German. It's in the book, I promise, in Democratic Justice. But that's what Nazi Germany is trying to convey. Frankfurter was nominated because people thought that he would be the great liberal leader on the Supreme Court of the United States. And he didn't live up to that promise. And one reason he didn't live up to that promise was World War II. And he spent most of World War II advising FDR, advising the Secretary of War, Henry Stimson, who he handpicked. Once war broke out, it was Frankfurter who orchestrated Stimson's return to Secretary of War because he knew Frankfurter thought this was the war to save civilization and anything goes. And that meant moonlighting as a policy expert in the War Department and in FDR's administration while serving on the Supreme Court, which today would never happen, but Frankfurter was very neglectful of his duties as a justice. He was compromised in a couple of really important cases. In the Japanese internment case of Fred Korematsu, he should have never sat on those cases while he was advising the War Department about policy. He should have never sat on the case called Ex parte Quirin about Nazi saboteurs when he was advising Henry Stimson about whether or not to hold a military commission. And his focus was just sort of elsewhere. And I think the breaking point for Frankfurter was in 1943 when he dissented from a Supreme Court decision which struck down a compulsory flag salute for 2 children of Jehovah's Witnesses. That was the point, I think, on the court where liberals Hugo Black and William Douglas really assumed the leadership of the Supreme Court of the United States, along with Frank Murphy and others. And Frankfurter was seen as this liberal turned conservative. Democratic Justice, my book, argues that I don't think that's really true because Frankfurter believed in the idea of judicial restraint. He believed that courts are not the place to make economic or social policy. We should make those through the democratic political process. But Frankfurter adapted judicial restraint in a way that was different from his 2 heroes, Oliver Wendell Holmes Jr. and Louis Brandeis. He believed that the 14th Amendment should protect the rights of African Americans, and he set out to do that in his opinions. This is an unpublished concurring opinion of Frankfurter's in Smith versus Allwright. This was a case about the all-white primary in Alabama. Frankfurter was initially assigned the majority opinion in this case. That assignment was taken away because Frankfurter was a Northern Jew, and people prevailed upon the then Chief Justice, Harlan Fiske Stone, to reassign the case to a Southerner because they thought the medicine would go down a little smoother from Stanley Reed, who by that time is on the Supreme Court of the United States, who's from Kentucky, then from Frankfurter. And Frankfurter was not satisfied at all with Stanley Reed's opinion. In the non-forthright way, it overturned a precedent, Grovey versus Townsend. And so he wrote this concurrence, and he said that what they were doing was enforcing the 14th Amendment and claims of citizenship free from racial discrimination. I wish he had published his concurrence, because he published a lot of concurring opinions and a lot of dissents. His critics would say too many concurrences and dissents, and this was the one he held back because Robert Jackson told him to hold it back, and I wish he had published it. That didn't stop him from enforcing the 14th Amendment and from really trying to enforce the rights of African Americans. In 1948, Frankfurter hires William T. Coleman, the future Secretary of Transportation, to be the first African-American law clerk on the Supreme Court. On Frankfurter's right is Elliot Richardson, Massachusetts' own Elliot Richardson, Attorney General in Massachusetts, also Attorney General of the United States under Richard Nixon, a part of the Saturday Night Massacre. Under Richard Nixon. They were really good friends on the court, but Coleman and Richardson were best friends since law school, and they were really close. But Coleman in particular taught Frankfurter a lot and wrote a memo about graduate school segregation cases that I really think helped Frankfurter think about how the court was going to end Plessy versus Ferguson's racially separate but equal doctrine when it came to education. I argue in the book that in 1954, Frankfurter was instrumental in achieving a unanimous opinion in Brown versus Board of Education, which outlawed racially segregated public primary and secondary schools. Earl Warren was a new justice. He was a recess appointment. When Brown was argued for a second time in the fall of 1953, Hugo Black was the acting Chief Justice to start that term, and it was really Frankfurter and Hugo Black who were helping Earl Warren learn constitutional law on the fly, learn really the dynamics of the Supreme Court, and how to bring everyone together behind a unanimous opinion. Where Frankfurter started to part company with his Warren Court colleagues, in which alienated his former student Charles Wazansky, was when we get to cases like Cooper versus Aaron. This is a case involving Arkansas Governor Orville Faubus disobeying federal court orders, mandating desegregation in Little Rock. William Brennan, by this time, a former Frankfurter student, has joined the court in 1956. He becomes Earl Warren's chief lieutenant. And it's Brennan who really starts to amplify the court's power by saying that the court has the last word on the Constitution, which is a pretty controversial concept. And in his majority opinion, he says the federal judiciary is supreme in the exposition of the law of the Constitution. And Frankfurter and his close colleague John Harlan thought this was the wrong way to go, that they could have talked about rule of law values, that governors need to follow federal court orders, not that the Supreme Court has the last word on the meaning of the Constitution. And that continued. Needless to say, his former student, Charlie Wazansky, was not impressed. And in 1956, Frankfurter received an honorary degree from Harvard College, or from Harvard University, that was long overdue. Frankfurter had been on the court for 17 years by that point. He finally gets this honorary degree, and they have a celebratory dinner at the Somerset Club, which Wazansky presides over. After dinner, Frankfurter gives a talk, and Robert Oppenheimer, the physicist, and Wazansky are there, and they're two of the younger people at the dinner, and they were not impressed. They thought Frankfurter's after-dinner speech was, quote, rather awful. And I can imagine what the after-dinner speech was like. I bet Frankfurter talked about coming to this country at age 11, not speaking a word of English. He was thrown into PS 25 in New York City, and Miss Hogan, his teacher, threatened his classmates with corporal punishment if they spoke to him in German, and about CCNY, and about finishing first in his class at Harvard Law School, and a lot of sentimentality about what it means to be an American. Well, Oppenheimer and Wazansky relay how awful they thought Frankfurter's speech was to the journalist Joe Alsop. And here's what Alsop wrote and how he responded to Wazansky and Oppenheimer. He said, "It gave me great pleasure to tell R. Oppenheimer and C. Wazansky, who were both rather patronizing about his intellectual powers, his meaning Frankfurter's, that I thought he was one of the 2 or 3 most useful American citizens of his time, solely because he had outlined a new standard of public service in America, had persuaded so many others that this new standard was valid and recruited so many men who exemplified what he was talking about. Well, that standard was really exemplified by Charlie Wazansky Jr. Himself, right, as this great lawyer in the New Deal and this fantastic federal judge. And what makes the story even more interesting is after Frankfurter leaves the court, and he's sort of regarded as this failure. After Frankfurter dies in 1965, around 1973, Judge Wazansky decides he's going to write the definitive biography of Felix Frankfurter, and it was this material in Wazansky's papers that was so helpful to me in writing the book. Wazansky interviewed a lot of people, including Frankfurter's sister, and one of the funny aside lines that Wazansky wrote in his notes was he wrote, Frankfurter's sister knows nothing about her brother. And I think he meant the law. She actually had some insights on his childhood, but I don't think they were really close later on, and Wazansky's comments reflected that. But Wazansky sort of concluded of Frankfurter that he was a historical mank, that he was a failure, right? That he had failed to achieve all of his promise. And I'm going to paraphrase another historian. A few years later, the historian Joseph Lash edited Frankfurter's diaries. And around 1975, Lash wrote that Frankfurter had become uncoupled from the locomotive of history, unquote. Those are Lash's words. And I find this very interesting, Wazansky's conclusion and Lash's conclusion. And I think you have to periodize it and put it back in its time. 1973 to 1975 was the heyday of the Brennan Court. William Brennan was at the height of his powers on the Supreme Court of the United States. He was cobbling together liberal majorities to protect the rights of women and minorities. And he was really into this idea as the court as the ultimate constitutional interpreter, as Brennan says in Baker versus Carr, and liberals' faith in Brennan and in the Supreme Court sort of reigned supreme at that point in time in the mid 70s. And Frankfurter really looked like he had misjudged the situation. But I would assert to you that Frankfurter's reputation looks a lot different in 2023 than it did back in 1923. And here's why. The Supreme Court, after Brennan left, got drunk on its own power, right? It asserted in a 1997 case called City of Bernie versus Flores, it basically eviscerated Congress's right to enforce the 14th Amendment. 3 years later, many of you will know, the Supreme Court of the United States interfered in the state of Florida's recount in the 2000 presidential election and short-circuited that recount in an opinion that most of you have heard of, Bush versus Gore. And their rationale was an equal protection rationale that was good for this train only. Well, that's not how the Supreme Court decides cases, right? The Supreme Court is supposed to decide cases on general legal principles and not on one train only sort of rationales. And after Bush versus Gore in 2000, academics and lawyers started to rethink Felix Frankfurter, and they started to look at Frankfurter's dissent in Baker versus Carr, which was the Tennessee reapportionment case, where Frankfurter warned people about the political question doctrine, which basically says that the Supreme Court should not interfere in inherently political disputes without a legally manageable standard. And he says, this is important, the political question doctrine is important. People started rereading that dissent and thinking, hey, maybe Frankfurter was right. Maybe the Warren Court shouldn't have overturned as many precedents as it overturned. Maybe the Warren Court was a liberal aberration. Maybe the Supreme Court is not the good guys. Maybe Congress is the good guys. And that's what Frankfurter thought all along. And I think he's been vindicated historically in large measure. If you look at something like the 1964 Civil Rights Act, Frankfurter was a huge fan of Lyndon Johnson's, the 1965 Voting Rights Act, and the Affordable Care Act more recently. Those are Frankfurter's method of constitutional change and of political and social change, sorry. That's the way that Frankfurter thinks that this democratic society should change things. And he was skeptical of the Supreme Court. And I think some of that skepticism's really been borne out based on the way the Supreme Court of the United States has eviscerated the Voting Rights Act in Shelby County versus Holder and tried to chip away at the Affordable Care Act. And so, I think Frankfurter is having a moment, right? And of course, the elephant in the room is Dobbs, right? Once Roe v. Wade was overturned by Dobbs, and Frankfurter was super respectful of precedent, got a lot of criticism from his liberal colleagues about his unwillingness to overturn precedent. Just to answer and anticipate the question, there's no way he would have been in the majority in that Dobbs case, because he's not overturning a 50-year-old precedent that people have relied on. So just to repeat, I think Frankfurter made two really enduring contributions to American law. First, he sent scores of talented Harvard Law students, like the great advocate and judge Charlie Wazansky Jr. into public service. And second, he reminded liberals and all of us not to put too much faith in the Supreme Court to solve all of our problems, and that people should invest themselves in the democratic political process. I'm going to end my talk there, and I'm going to reiterate my gratitude to the Massachusetts Historical Society for having me, for Charles Wazansky Jr. for depositing his papers at the Massachusetts Historical Society, and to the audience here and at home for listening to my talk. And at that point, I'm willing to answer questions.
Thanks. Two kind of related questions. How did he get so influential in the Roosevelt administration? Roosevelt did not go to Harvard Law School. He went, I think, to Columbia. And second, what was his relationship with the Kennedy family? One of the David Nassau quotes has Frankfurter throughout the book on the Joseph P. Kennedy biography.
First of all, the David Nassau biography of Joe Kennedy is amazing. It's called The Patriarch. I highly recommend it. It's a great book. Those are both great questions. So in 1928, Frankfurter backed Al Smith for president, as did his then friend, Walter Lippmann. They basically became frenemies and then enemies. But in 1928, Al Smith got trounced by Herbert Hoover. He even lost his home state of New York. Al Smith was the governor of New York. But in that very same election, Franklin Roosevelt narrowly won the governorship. And Frankfurter saw in Roosevelt, first of all, they had worked together in the War Department during World War I. When Frankfurter was the head of the War Labor Policy Board, Roosevelt, who was the Assistant Secretary of the Navy, I think, he was on that board, and they became friendly. I'll say this quote, but when Frankfurter went over to the Roosevelt home, Eleanor remarked, "A very nice man, but very Jew." Was what she said at the time, that she was obviously more prejudiced then than she became later on in his life. So they had been friends for a long time. But Frankfurter recognized something after the 28 election. His friend Walter Lippmann was in despair. He thought the Democratic Party was over, and he thought that there was no one to lead them forward. And Frankfurter said, not only will the Democratic Party be the liberal party in this country, and that was a bold statement, because there were liberals in both the Democratic and Republican parties at that point in time, but that Franklin Roosevelt was the future of the Democratic Party. And Walter Lippmann thought the opposite, right? Walter Lippmann in 1932 wrote an op-ed saying that Franklin Roosevelt is a lightweight, this is January of 32, and is unfit to be president of the United States. He was trying to prevent Roosevelt from getting the Democratic nomination. So from 28 to 32, Frankfurter is advising then Governor Roosevelt about all sorts of things, including water policy, criminal justice, economic reforms. So they become incredibly close. And during that 28 to 32 period, Felix and Marion Frankfurter are making all of these visits up to Hyde Park. So by 33, it's natural. Franklin Roosevelt wants Frankfurter in the administration. Frankfurter turns down the job of Solicitor General because he thinks that he can do more good to Roosevelt on the outside than inside the administration. And Frankfurter realized that being Solicitor General under Roosevelt was going to be a Herculean job, especially with a very conservative court, and that he couldn't both be Solicitor General and advise Roosevelt. The Kennedy thing is super complicated. Okay, so the old man, Joe Kennedy, was basically using Frankfurter as his educational advisor. And it was Frankfurter, and so after Joe Jr. and Jack graduate from high school, he goes, where should they go? And Frankfurter has both of them go study with his good friend, a socialist, Harold Laski, at the London School of Economics. And he says, Harold Laski's the greatest teacher in the world, and your boys should go study with them. And Joe Jr. liked studying with Lasky. Jack claimed health problems in the new great book about Jack Kennedy, the first volume, Frederick Lodgewall. His book's amazing. Jack basically feigned illness to stop studying with Harold Lasky. So they're close until the 30s, right? And until the mid-30s even when the Frankfurters go to London, they visit the Kennedys, right? And Frankfurter would visit the Kennedy compound, but once Joe Sr. becomes this Neville Chamberlain appeaser, right, who doesn't want to help the Jewish people in any way, shape, or form, Frankfurter parts company with him. And then when Kennedy gets removed as the ambassador to Great Britain, he blames Frankfurter and the Jews in the administration. He starts spreading a lot of anti-Semitism about Frankfurter and about Frankfurter's New Deal allies. And so the two people that Frankfurter hated the most in life was Joe Sr. and William O. Douglas, and they both happened to be good friends. But those were the people that Frankfurter thought were the only two truly evil people that he had ever met. And in fact, Frankfurter never really warmed up about Jack Kennedy as president because he really just couldn't get past his hatred for the old man. Even though the beginning of my book opens up with Jack Kennedy as president visiting Frankfurter at his house, he really doesn't like Jack Kennedy. He didn't see what all the fuss was about Jack Kennedy. He kind of thought that Jack Kennedy was a little bit of a callow lightweight and a showboater and not really a legislator like Lyndon Johnson. That was a long-winded answer, but those were great questions. Anybody else?
What about Frankfurter and the court packing plan? I mean, that to me undermines your thesis to some extent as to him being not wanting the court to be political, and unless, I mean, he was quiet, was he not, as to the court packing plan with Roosevelt?
Well, I just want to introduce Judge Wazansky's son. I'm Charles Wazansky here. Thank you for coming. And I forgot to do it earlier, and thank you for being here, and I've enjoyed corresponding with you on email. So the court packing plan is a complicated thing, and it's one of the favorite chapters of mine that I wrote in Democratic Justice for reasons that are kind of different than your question, and I'll tell you why I liked writing that chapter almost more than any other. So when Roosevelt announces his plan to increase the number of federal judges for everyone over the age of 70 years and 6 months who hasn't retired, he doesn't reveal this plan to basically anyone. There's about 5 people who know about the plan. And in fact, shortly before he announces the plan, he says he writes Frankfurt, he says, you're going to be in for a shock, an awful shock. Just promise me you'll reserve judgment until you hear why I did it. And so Frankfurter agrees, and he's shocked, and he doesn't think the Supreme Court should increase from 9 to up to 15 justices, but he does think the Supreme Court of the United States is out of control, and that these anti-New Deal justices, there's 4 of them, and then Chief Justice Hughes and Owen Roberts are joining them to strike down a lot of New Deal programs. He does think the court is playing politics, and does think that they are reading their economic biases into the Constitution. So he helps Roosevelt. He remains publicly neutral about the court packing plan, much to the consternation of some of his close friends, right, who are urging him to speak out against the court packing plan, as your father did. But he remains neutral, and yet behind the scenes, he's helping Roosevelt make the case against the Supreme Court of the United States. The reason why I thought Frankfurter's reaction to court packing was super interesting was I argue in the book that it almost irreparably damaged his relationship with Justice Louis Brandeis, that they almost broke over the court packing plan. Frankfurter was really disappointed with Brandeis's role in signing he really didn't know the extent of it, but really Brandeis was helping Chief Justice Hughes, who was helping a U.S. senator thwart the court packing plan because FDR offered this bogus rationale on why to increase the number of judges. He said they were behind on their work. Well, that was insane. That was just a pretext. And what the letter that Charles Evans Hughes wrote and that Brandeis signed was that the court was totally abreast of its work. And Frankfurter never really forgave Brandeis for signing that letter and injecting himself into what he viewed as a political dispute. And I think on the other side, I think Brandeis correctly saw Frankfurter as too close to FDR and unwilling to separate his relationship with FDR from what he felt about the court packing plan. And they almost stopped speaking because of court packing. And it took a friend of theirs, Julian Mack, the first Jewish federal judge, to kind of intervene and bring those two kind of back together. And there's some letters back and forth that Frankfurter wrote during that time period and after the switch in time in which the court sort of flipped on Roosevelt's New Deal programs and started upholding them that show a lot of anger and hostility from Frankfurter to Brandeis and the rest of the Supreme Court. I don't know if I answered your question, but I think he believed the court was political, and he thought it needed to be stopped. But he didn't agree that the way to do it was to increase the number of justices from 9 to 15.
Why did he hate William O. Douglas so?
Well, he hated. They started out as friends. So when Frankfurter's nomination was announced in 1939, William O. Douglas, with other young New Dealers, he was the head of the SEC at the time. He was celebrating with glasses of champagne with Tom Corcoran, Robert Jackson, and all the other young Turk New Dealers. But they kind of turned on each other when they got on the Supreme Court of the United States. Frankfurter thought William O. Douglas was more interested in succeeding FDR as president than in doing his job at the Supreme Court of the United States. And in the 1940s, he thought that some of Douglas's votes were with an eye on the White House. Douglas thought that he was going to join Roosevelt's ticket in 44. In fact, he was one of two names submitted for the vice presidency in 44, and there's a story that Douglas's name was first and Truman's name was second, and someone flipped the order of those names. Now that story hasn't been corroborated anywhere, but that was the story at the time. But there was just a lot of venom back and forth. It got really nasty. It got really personal, and they just hated each other. I write in the book, and I've gotten criticized for this, but Frankfurter also saw a whiff of anti-Semitism in Douglas. And this came from an interview that I read from Alexander Bickel, who was one of Frankfurter's favorite law clerks, that's at the FDR library. And Bickel pointed to some specific instances of cases where Frankfurter thought there was just a whiff of anti-Semitism in Douglas. And I think Douglas's association with Joe Sr. Didn't help. I think it just added fuel to the fire. But they really hated each other. It got really personal and vituperative, and it was disruptive to the court as an institution. They really just didn't get along, and I think neither of them could say a kind word about the other person.
We have some questions online. So Gavin is talking here about the final opinion of Baker versus Carr, in which he urged the court to stay out of the political thicket of legislative appointment, and asks, what would Frankfurter think of our modern judiciary and appointment process, and what would he most want to change?
Ooh, that's a great question. What would he most want to change? Well, of course, Frankfurter thought the court should have stayed out of that Tennessee reapportionment case, and the court shouldn't have gotten involved because it couldn't come up with a legally manageable standard. The court relied on a very flimsy equal protection rationale that Justice Brennan wrote was well developed and familiar. That's how he stated the equal protection rationale. It was not one person, one vote. That was Reynolds versus Sims in 1964, 2 years after Frankfurter left the court. But I think Frankfurter would be really sad about how politicized the nomination process has become. And he would be really sad about the Supreme Court's willingness to strike down federal laws. And he would be sad about the way, and this is Justice Kagan's words and not Frankfurter, the way the First Amendment has been weaponized, both free speech and free exercise, to strike down laws of general applicability or to create carve-outs of laws of general applicability like anti-discrimination laws in Colorado. I think he'd be very sad that people are making free exercise and compelled speech claims to try to not abide by anti-discrimination laws. So I think he'd be dismayed about how powerful the court has become and about the way the court is using its power.
Another question is, they're asking to what degree you believe Frankfurter's personality traits may have diminished his influence among his fellow justices, having a tendency to dryly lecture his colleagues, and why was he not a better consensus or coalition builder?
Yeah, that question is totally right. This idea, Frankfurter was very pedantic. I think his biggest flaw, though, even more than being pedantic, was he tended to personalize disputes. So when he got in a dispute with William O. Douglas, or he got in a dispute with Hugo Black, he couldn't just argue on the merits of that dispute. He tended to resort, in addition to the legal dispute, to personal attacks, and that made him very ineffective as a justice on the court. And he alienated a lot of his fellow justices. He had a lot of really good friends on the court. He was really close friends with Robert Jackson, really close friends with Owen Roberts, really close friends with John Harlan. But he alienated a lot of chief justices, and he didn't get a lot of great assignments for majority opinions. So he didn't write a lot of really landmark majority opinions. Smith versus Allwright got taken away from him. I'd say Gamillion versus Lightfoot and Chenery is an administrative law opinion, maybe the best known Frankfurter majority opinions. He was in a lot of ways like Scalia, right? Who did not suffer fools, and who did alienate his colleagues, and except for Heller, the gun rights case, did not write a lot of majority opinions either. But that doesn't mean that Scalia wasn't influential as a textualist and an originalist, and it doesn't mean that Frankfurter wasn't influential about his ideas of judicial restraint, yet enforcing the 14th Amendment to protect the rights of African Americans. I think some of it's a little bit overrated that he wasn't more effective inside the court. I mean, Brennan was really effective inside the court. He was great at building coalitions. But the question is, did he damage the court as an institution by citing Marbury versus Madison and declaring it the ultimate constitutional interpreter in Baker versus Carr?
What do we know about his religious biography?
Okay, well, so, I've been on the Synagogue Tour of America, and I stepped off to be here at Massachusetts Historical Society, and I usually give a talk about a lot of the Jewish aspects of his life. Frankfurter left synagogue at age 15. He never went back. He felt like a hypocrite sitting in synagogue when he didn't believe in God. But like Brandeis, who was also not a practicing Jew, Frankfurter became an avid Zionist, and there were not a lot of Zionists in America, even among Jews, in the teens, but it was Brandeis and Frankfurter and Judge Mack who were basically the de facto leaders of the American Zionist movement. In fact, Frankfurter went to the Paris Peace Conference in 1919 to try to procure a Jewish state. And then when he realized that Wilson wasn't going to make it happen, he sent Brandeis to Palestine on a reconnaissance mission, and other people were telling Brandeis, it's too unsafe in Palestine for you to go. And Frankfurter said, they're crazy, you should go anyway. This is a picture of Brandeis in Palestine. They said he almost looked like a changed person in Palestine. But the neat thing was that Frankfurter saw this sort of Zionist project all the way to the end because he lived so long, right? So in 1948, I'll get there, I promise. Oh, during the war, he's helping getting a lot of Jewish refugees, including academics, out of Europe in the early 30s. But he's got two aides working for President Truman, Dave Niles, who's from this city, Boston, and Max Lowenthal, who are both aides of Truman, and they're doing Frankfurter's bidding on getting the United States to be the first country to recognize the state of Israel. And this is a picture of the first president of Israel, Chaim Weizmann, visiting Truman at the White House. And Chaim Weizmann gives Truman a Torah at the White House. This is a picture, and Truman exclaims, "Oh, a Torah, I've always wanted one." And Dave Niles sort of burst out laughing with Truman's comment. But Truman was actually great on the Jews, and in many ways better on Jewish issues than FDR was. And I think, I don't have any evidence of this, but I think FDR's unwillingness to confront the anti-Semites in the State Department really saddened Frankfurter. Frankfurter went to Cordell Hull to try to get more Jewish immigrants into this country and refugees. He went to Francis Perkins, who was in charge of immigration at that time, and he tried to get more immigrants. But confronting FDR wasn't a good strategy because FDR was kind of a sphinx, and he left you leaving his office thinking he agreed with every word you said when in fact he didn't. So I think Frankfurter was a very Jewish person, even though he wasn't a practicing Jew, is my sort of my long-winded answer.
Well,
One question. Thanks for a great talk and a great book. There have been justices who have been skeptical of judicial power because they were more anti-court than they were pro-politics. But he actually experienced politics, so I don't know if there's other justices who've been as pro-politics who've experienced politics. So would you say that that part of his life, that part of his professional identity left him positively inclined towards thinking of politics as like a constructive, positive thing? That's my first question. The second question, I guess, is you really think he was right in Baker v. Carr? You really think it's good for the court to stay out of gerrymandering, all these other disputes? But you could ignore that question.
See, this is the problem when you have law professors who parachute into your talks. No, I'm just kidding. David, those are both great questions. Thanks for coming, my dear friend David Fontana. He had many positive experiences working in the Taft administration, from then Secretary of War Henry Stimson, working in the Wilson administration, both in the War departments and the Labor departments during World War I. And then I think he had a lot of success in government in those early FDR years. He was helping draft FDR's legislation in '35 for the Second New Deal. So he had a very positive view of politics. I think you're absolutely right. I think the other justice who's similar to him, I know you're going to think this is kind of odd, is Hugo Black, right? Because Hugo Black was a great New Deal senator. He voted all the way down the line with Roosevelt on just about everything. And I think, Black, even before he left the court, he drafted the Fair Labor Standards Act. I think he too had a lot of really positive experiences in federal politics before joining the Supreme Court. On the Baker v. Carr thing, I'm kind of with Bickel, right? So in my book, I have a back and forth between Frankfurter and Bickel about Baker versus Carr after that opinion comes down. And Bickel's point was, hey, the state of Tennessee's failure to reapportion for 60 years is so egregious that the court needs to say, hey, by virtue of not reapportioning your state legislative districts for 60 years and having these rural legislators have so much more power than the urban ones, that's a due process violation then and there, right? Regardless of what the standard is going forward. And I'm sort of with Bickel on that, but I reject the kind of the court's well-developed and familiar equal protection rationale on which that opinion was based. And I definitely reject the kind of highfalutin language of the ultimate constitutional interpreter, C. Marbury versus Madison, that Brennan uses. So I'm sort of with Bickle that the court got the outcome right, but wrote the opinion wrong. I appreciate the question on that one.
Okay, well, I want to thank you very much for a great presentation. We have books available in the lobby, and I want to thank everyone who is joining us online as well. So thank you very much.
Thanks, Gavin.